Debate. Thank you, Madam Speaker. Honourable Senators, today we find ourselves in a rather singular situation. Our chamber has conducted an exceptional study of Bill C-45. We have heard from over 240 witnesses and received a number of briefs. We have asked relevant questions and have had clear answers for most of the time. We took the time to properly reflect, and we have debated the issue serenely. That is our fundamental role, because that is what we are debating right now, the role of the Senate. I must admit that I am disappointed by the government's position. In its response, it is demonstrating that it has little consideration for the impeccable work and nonpartisan work that we deliver. But that is its prerogative. Concerning the message from the House of Commons, I would like to speak first of all about Amendment 25 on transparency and publication of the names of administrators, directors, and investors in cannabis-producing companies. I don't understand the government's position. The objective of the government is to withdraw organized crime from the cannabis market. And yet, the Royal Canadian Mounted Police says that the legalization of marijuana will not eliminate organized crime from illicit commerce of this drug, despite the claims of the Trudeau government. Allow me to quote Commissioner Kevin Brosseau. Given the scope of the involvement of organized crime, we are not expecting that this bill will eliminate the presence of organized crime in the cannabis market. It will reduce it, but it will not eliminate it. Over half of cannabis that the Société des Alcools du Québec plans to purchase comes from businesses funded by tax havens. Quebec concluded that contracts with 6 companies to supply the Société Québécoise du Cannabis, which will fall under the SAQ, which will have the monopoly for selling the pot in Quebec. 3 of these firms, which will provide 33,000 of the 62,000 kilograms of marijuana that Quebec plans to purchase in 2018-2019, receive tens of millions of dollars from tax havens. To my great surprise, our amendment on tax havens was rejected by the government. I must conclude that the Prime Minister is approving the use of tax havens to invest in cannabis companies. It's very concerning. 35 out of 86 producers authorized by Health Canada, namely 40% of them, have benefited from offshore funding in the last 2 years. Honourable Senators, you will agree, if we wish to fight against the activities of organized crime, it would have been imperative to prevent it from integrating into the legal cannabis market under the cover of anonymity or or through tax havens. But the government rejected this amendment, which nevertheless received strong support from senators, and that leaves me without words. The organization Transparency International Canada reacted thusly to the amendment. This amendment is a crucial and important step which will unveil those who could abuse cannabis producing companies and their funds to hide the source of funding and the wealth of their true owners. The response from the government is also paradoxical, and here it is. It respectfully rejects Amendments 17A and 25 because other amendments made by the Senate, other than what the House accepts, would give the minister increased powers, allowing them to require safety, and that Amendments 17A and 25 would present significant challenges at the operational level and concerns about privacy. Should we understand that before an operational challenge, the government is abdicating its responsibilities to eliminate the presence of organized crime in the cannabis industry? But isn't that exactly one of the objectives of Bill C-45? Furthermore, we are now facing a message from the House of Commons that leaves me dumbstruck. The Prime Minister and his ministers have implied that the federal legislation that would apply would authorize the home growth of 4 plants in opposition with Quebec and Manitoba's plans to strike it. By doing this, the government is sowing confusion among Canadians. Let's not forget that Bill C-45 amends the Criminal Code. it is useful to remember that federal jurisdiction is responsible for criminal law. The three components of a criminal law are a ban, a sanction that supports it, and thirdly, a public nature objective that allows it to be tied to criminal law. Essentially, the criminal code bans behaviors. The exercise of this jurisdiction does not allow to create a right or promote actions. Furthermore, government representatives mentioned at the hearing that the section on home cultivation did not create rights. Madame Lebel from the Department of Justice said this on March 21st, and I quote, "I can say, however, that we drafted the bill with great detail to not create a transfer of rights or a right. I am not certain how a challenge would be handled. It is not a right of possession. It is not a transfer of right of possession. It is simply the fact that criminal law does not apply." End of quote. And yet, in its response, the government is maintaining confusion with respect to these important distinctions. Let's read the message concerning Amendment number 3, which says, it respectfully rejects Amendment 3 because the government was clear that the provinces and territories are capable of imposing additional restrictions concerning home cultivation, but that it is essential that personal cultivation be allowed in order to support the government's objective to displace the illegal market. End of quote. Any person with a lick of sense would understand reading this text that the federal government is authorizing home cultivation instead of removing the prohibition for fewer than 4 plants. In the decision on assisted procreation, Chief Justice McLaughlin mentioned this concerning the federal jurisdiction.
Contain a prohibition prevents Parliament from undermining the provincial competence in health. The federal criminal law power may only be used to prohibit conduct and may not be employed to promote beneficial medical practices. Federal laws, such as the one in this case, may involve large carve-outs from practices that Parliament does not wish to prohibit. However, the use of the carve-out only means that a particular practice is not prohibited, not that the practice is positively allowed by the federal law. This has an important implications for the doctrine of federal paramountcy. If a province enacts stricter regulation than the federal government, there will be no conflict in the operation between the two sets of provisions, since it will be possible to comply with both. Further, there will be no frustration of the federal legislative purpose, since federal criminal laws are only intended to prohibit practices. A stricter provincial scheme will complement the federal criminal law. There may be a conflict between a criminal law and a less strict provincial scheme. Fin de la citation. Ce qui nous amène
Which brings us to elaborate further on the preponderance of federal legislation in cases of conflict with provincial legislation. What does that mean exactly? Federal legislation, which is duly passed, supersedes any legislation equally valid but incompatible with it. To apply the principle, there must be a conflict between two laws. There is a conflict when, 1, the application or complementary application is impossible, either that following the law would result in a non-respect of the other law, or 2, that the provincial legislation sidesteps the objective of the federal legislator. Following jurisprudence in the matter, the degree of incompatibility is important. In the Irving Toy decision, the following was said: the fact that provincial legislation includes more severe requirements than the federal legislation or additional requirements cannot result in incompatibility of application. They can conform with both, end of quote. Also from Quebec, the Attorney General against the Pilots Association in 2010, paragraph 66 said, generally speaking, the Supreme Court has deemed that the standard for invalidation of a provincial legislation on the grounds that it contravenes the realization of a federal objective is high. A federal act cannot allow the establishment of harm of its objective by a provincial legislation. For the principle of federal law to apply, the federal law must be valid and justified through one of its jurisdictions. However, the federal and provincial legislation are pursuing the same objectives, namely to distance youth from cannabis and eliminate the illegal market. To name just two objectives, the two acts, federal and provincial, can exist together without there being conflict. They are two distinct means of reaching the same destination. But, honourable senators, with the statements by the Trudeau government's ministers and with the text of the response from the House of Commons, it seems essential that we insist on maintaining Amendment 3 to integrate in Bill C-45 an interpretive clause to recognize the provincial jurisdiction to regulate the use of cannabis in their territory. Yesterday, Senator Harder gave a long speech encouraging us to support the government's position. Over 8 times, the Senator Harder confirmed that the provinces could limit the number of plants between 1 and 4, but not 0. I would like him to point out to us in the bill where the provinces can limit to 1 plant but not 0. They cannot do so because it simply does not exist in the bill. Senator Harder says that condo owners could regulate to ban home cultivation, but not provincial governments. Senator Forêt rightly highlighted this contradiction in Senator Harder's comments. In April, Minister Fournier, before the Legal and Constitutional Affairs, justified the home cultivation ban set out in the Quebec legislation by invoking the protection of youth. He said that the possibility of growing marijuana at home created an opportunity for the illegal market. He had the same objectives as the federal government, so therefore there cannot be harm to either the federal or provincial laws. That is why, honourable senators, in amendment, I move that the motion not now be adopted, but that it be amended by deleting in the second paragraph the reference to Amendment 3 and the word "and" at the end of the paragraph in the English version, and by replacing the third paragraph with the following: that the Senate insist on its Amendment 3, to which the House of Commons has disagreed, that pursuant to Rule 16-3, the Standing Senate Committee on Social Affairs, Science and Technology be charged with drawing up the reasons for the Senate's insistence in its Amendment 3, and that the committee present its report with the reasons for the insistence on or before the first day on which the Senate sits after the adoption of this order, and that once the reasons for the insistence have been agreed to by the Senate, a message be sent to the House of Commons to acquaint that House accordingly. It is moved by the Honourable Senator Carignan, seconded by the Honourable Senator Andrzejczyk, that the motion not be now adopted, but that it be amended by deleting in the second paragraph the reference to Amendment 3. Dispense. On debate. Senator Boisvenu. Thank you very much, Madam Speaker, rather. Honourable Senators, I rise today to support Senator Carignan's amendment. This important amendment seeks to correct a grave error in the message by the House of Commons received yesterday. I must insist that Amendment 3 be maintained in Bill C-45. Amendment 3, which we, Conservative Senators, invite you to maintain and keep in C-45, seeks to preserve the competence of the jurisdiction of Quebec and the provinces which seek to ban home cultivation of cannabis in a home. Senators, the rejection of this amendment would go against the legitimate objectives of the National Assembly of Quebec. The National Assembly of Quebec, I will remind you, passed a few days ago a bill that would ban the home cultivation of cannabis. This bill is the fruit of a number of consultations of experts and public servants who truly understand Quebec. To repeat the words of the Quebec minister in his speech at the National Assembly, and I quote, we have established a committee that include over a dozen of departments, and there's the Department of Health and Social Services, the Department of Economy, Science and Innovation, the Department of Municipal Affairs and Land Use, Department of Agriculture, Fisheries and Foods, Department of the Executive Council, Department of Public Safety, and so on and so forth. You will understand, colleagues, that Quebec's position is based on the Quebec reality. I cannot remain silent about the legitimate position of Quebec, which is supported by scientific and serious evidence. The government of Quebec has also held consultations in all regions of the province. The regional consultation process traveled to the cities of Rimouski, Quebec City, Saguenay, Trois-Rivières, Granby, Montreal, and Gatineau. 128 briefs were tabled by organizations, and 570 citizens participated in the consultations. The Quebec minister was also present at all of these consultations. The consultation process established by the government of Quebec also took the form of an experts forum on the framework for cannabis. Over 200 experts from a variety of sectors discussed the Quebec issues tied to the framework. Finally, Quebecers were invited to respond to an online consultation between August 21st and September 12th, 2017. 12,594 Quebecers responded to this poll. In comparison, the consultation of the Federal Working Group on the legalization and regulation of cannabis is much less impressive. It reached only 2,022 participants in Quebec. 6 times as many were reached by the provincial poll. On the basis of these consultations, Quebec passed its bill. This bill is based on principles of health and public safety. That is, these are the principles that support the Quebec's position, which is to ban home cultivation. Quebecers want there to be restrictions on home cultivation. As a Quebec senator, I have the responsibility to represent Quebec in the federal sphere. On June 13th, the delegated minister for public health in Quebec, Madame Lucie Charlebois, clearly resumed the legitimate position of the Quebec government, and I quote, "I expect our fields of jurisdiction to be respected. If there is a legal battle to be waged, we will do so." In a speech that she gave to the National Assembly on June 11th, the minister responsible for this file explained one of the reasons, and I quote again, "It would have been cohesive for the minister to accept our proposal to legalize and to accept that for personal use, people cannot grow their own plants. And I repeat, to diminish the harmful consequences on the social sphere of the social problems tied with the addiction problems. As a Conservative senator and representing the interests of Quebec in this place, I cannot participate in creating this conflict between Quebec and Ottawa. I expect them to respect the jurisdictions as they do with Quebec and Manitoba. When the Trudeau government says no to Quebec, he says no to the National Assembly. I am very proud as a senator for the district of La Salle, a Senate district at the heart of Quebec, to speak on behalf of Quebec as by supporting Senator Cagnon's amendment. Voting against Senator Cagnon's amendment means opposing the legitimate right of the National Assembly to apply its own bill, which is the result of intense consultations. Voting against Senator Cagnon's amendment is like sanctioning the irresponsible position of the irresponsible Liberal MPs who have never spoken on behalf of their province in this debate. Honourable senators from Quebec, in this place, you have a fundamental question to ask yourselves when you have to vote for or against Senator Cagnon's amendment. Do I represent the interest of Quebec, or am I representing the interests of the Prime Minister of Canada? Thank you very much. Senator Pat, is it a question? Yes, I have a question. Senator Boisvenu, would you take a question? Yes, Madam Speaker. Senator Pat, you have the floor. Senator Boisvenu, you spoke about the consultations, the very exhaustive consultations that Quebec had on home cultivation, on legalization of cannabis. You mentioned the fact that over 12,000 people were consulted in this online consultation. But how do you interpret the fact that out of the 12,000 and some individuals who were consulted, over 60% of them said that they supported home cultivation? Senator Boisvenu. Yes, I understand the position of people who responded to the poll. But despite the fact that people who responded to the poll, the government of Quebec, on a public safety basis, feels that home cultivation of marijuana is a risk to health and a risk to the social integration when cannabis is legalized. This is a choice that Quebec has made, and it is a choice that I respect as a Quebec senator. Senator Gold. Thank you, Madam Speaker. Dear colleagues, I rise today as a senator from Quebec to explain why I will not support the amendment. And I will give you my reasons in the spirit of transparency. First of all, as you know, I strongly support this bill. I have argued and voted against several amendments, both at committee and in the chamber, because I thought they were inconsistent with the objectives of the bill. I voted against others because I strongly opposed delaying the coming into force of the bill. But I strongly supported the amendment on home cultivation, which is at issue today, and I believe that the government was wrong to reject it. I do understand the government's argument. I believe it has merit. However, I am not convinced that prohibiting home cultivation would necessarily compromise the objective of reducing the illicit market, especially if steps were taken to ensure that the price of legal cannabis in more remote regions was comparable to that in urban centers. But even if there is a strong case that the provincial ban would be compatible with Bill C-45, and I think that there is, I perhaps am in agreement with Senator Carignan concerning this aspect of constitutional law, our favorite subject. I supported the amendment in question because it would clarify the uncertainty surrounding how the federal and provincial laws would interact. Moreover, this accords with my sense of the right balance to be struck in our federal system between the exercise of federal and provincial legislative jurisdiction. But secondly, let's be clear on what is and what is not at issue here. This is not an attack on provincial jurisdiction. This is not a case of the federal government pursuing a highly centralized vision of federalism to bulldoze the provinces. It's far from that. Bill C-45 and the federal government's approach includes a broad variety of ways in which provincial jurisdiction is recognized and accommodated. It was set out in Senator Harder's speech, and I will not repeat it here, except to add one thing. Senator Carignan mentioned where in the Bill C-45, in the text of Bill C-45, is there this reference to the provincial legislative means, but that it doesn't exist, he says. Well, listen, it doesn't have to be there. It comes directly from the Constitution itself. In Section 8213, Property and Civil Rights, it is clear that the province has the jurisdiction to legislate. It has done so in a number of ways. And also at the same time, and just to add, there is no doubt that the federal power to legislate on criminal law is sufficient and clear to support Bill C-45 concerning decriminalization of possession or home cultivation of up to 4 plants. There is no question on the constitutional rights that the 2 fields of jurisdiction are respected. So what is the issue? This is simply an argument on one branch of the doctrine of the preponderance of constitutional law, a subject that concerns us for better, more and more for better and for worse. Here, the bill and the rejection of the amendment is a refusal to accept an amendment to eliminate an area, a gray zone, about the scope of provincial jurisdiction. I continue to think that the amendment is a good idea. So why am I opposed to it, you might ask? Why do I oppose Senator Cagnon's amendment? I have 2 reasons. First of all, I believe that we need to base ourselves on the principle of decision-making, that our positions are coherent and consistent. I strongly support Bill C-45, as you know, and I have sustained that delays will harm us. Although the government has not accepted the amendment, it recognized that, and there are a broad array of regulations at the provincial level that will comply with the approach of Bill C-45. And honorable senators, we have done our work well. We have been heard. We have fulfilled our responsibilities to the people we represent, and we represent Canadians. We are not here to represent provincial governments. That is not our role. It's not our responsibility. Excuse me. We have fulfilled our responsibilities toward all Canadians and Quebecers as well. And that brings me to the second reason, my understanding of our constitutional role as the legislative, independent, complementary body in the parliamentary system. Honourable senators, there have been circumstances in which the Senate has insisted on amendments, and there will be, these circumstances will exist in the future. But when I consider all the competing considerations concerning this bill, this government message, I have concluded that this is not one of those circumstances. This is not a frontal assault on provincial jurisdiction. In fact, it is not an assault at all. It is not an attack on vulnerable minorities. It is a disagreement. It's not, the government is not being unreasonable. It is a disagreement with a few provincial governments about one branch of the paramountcy doctrine in constitutional law. In my opinion, it does not rise to the level where our constitutional duty to resist the policy decisions of the elected House comes into play. Our job in the Senate is to provide critical scrutiny of legislation and to improve it where appropriate. Our role is to complement the work of the House of Commons in the legislative process. That is what we have done. And so, in my opinion, in my humble opinion, it is time to accept the legitimate decision of the House of Commons, and I will vote against the amendment. Thank you. Senator Malte. Thank you, Mr. Speaker. I will not repeat what my colleague Senators Carignan and Boisvenu clearly explained, but I will look at one thing. Confrontation. We are heading towards a constitutional crisis. The government of Quebec has announced it. The federal government will need to face it. The Manitoba government has made an announcement, and we will have to face this as well. Why are we at this juncture? Well, simply because the federal government has forgotten one thing. Before venturing into this bill, it should have had the provinces on board. It would have been so simple. I would speak to my honorable colleague, the Senator Gold, about constitutional crises. They are kicked off by small things. In your youth, you will perhaps not remember the crisis in 1982, where Quebec did not sign on. I would remind you, I was at the National Assembly at the time. Everything went sideways, and Quebec never signed on to the Canadian Constitution, despite the efforts of Prime Ministers Mulroney and Premier Brossard, despite the Meech Lake Accord, despite the Charlottetown Accord. We are still waiting.
A bill like Bill C-45 flies in the face, if you like, of the National Assembly of Quebec and that of Manitoba. Why? Because I would refer Senator Gold to section 93 of the Constitution that deals with the provinces. I'm sorry that he is not listening to me, but really he should. It would be to his advantage. Quite simply, what do I do, or should I just wait, Mr. Speaker? Quite simply, if we are where we are now, it's because of a lack of consultation. And a lack of consultation is serious. You will see what happens. Look at what is happening in our country. And, Mr. Speaker, goodness knows if a parliamentarian that has defended the Constitution and rights for 35 years, it is me. I fought for 35 years to keep Quebec in the Constitution. I spent 25 years of my life fighting to keep Quebec in the Confederation that our forefathers built since 1867. They did not found it on confrontation, but on understanding, respect of jurisdiction. And that is what created today's Canada, notwithstanding what was sent by Senator Harder, and I listened with great attention to his speech. I will just say to him, pleasantly, smiling, that if this is the new Confederation, last night you said to me, welcome to the new Confederation. Well, that Confederation is not one I want. I want cooperative Confederation, one that gets along with the provinces and which avoids confrontation with the two provinces that we see now. Just remember, there's a whiff of change in the air, and things can really get bad in a year, 2 years, 3 years. You will see that the situation may be difficult. Ask your questions then to the provinces and see what they answer. Mr. Speaker, if we are where we are now, it's because of a lack of understanding, of agreement. I respect I speak for the district of Shawinigan, and in fact, the Right Honourable Jean Chrétien is part of my senatorial district. When senators are sworn in, they sign. They must take the interests of their provinces, their National Assembly, and the concerns of our country in hand to work together to avoid any confrontation that will end up before the courts. For years now, that's been the case because we have not been able to reach an understanding, to reach agreement. We know that according to the banks, there will be stagnation over coming years in the economy, and Canada should not launch a constitutional war that will finish goodness knows where. Will there be winners? No, there will not. Be it the federal government or the provinces, there will be no winners. All that, Mr. Speaker, and I humbly remind you, just to implement a piece of legislation that will be used to sell drugs in our country. Is it necessary? If Canada were at war, well, I would certainly vote in favor of the supply that Canada needed, the monies that Canada needed, but all this loss of time to allow our country to become a mere pusher. It seems to me that we should be doing other things in our country. There are other things that should be done. There is no grounds for constitutional confrontation on this basis. And when the senators rise to vote on this matter, I ask them all to think of their province, think of their region. Think of the balance. It's very important. We'll all be going home in a few days, and we will be accountable for our actions. We will be going back to Quebec. I invite you to go to the barricades with me.
Question?
No on debate on the
On debate, I'll
amendment.
put you on the list, okay? Senator Pratt.
Thank you, Your Honor. Honorable Sénateur,
Honourable Senators, of all the amendments that the Senate has moved in the House of Commons, rather in the other place, there is one that I think is particularly important. It's the one that protects the jurisdiction of the provinces with respect to the growing of cannabis. It is important for two reasons. First of all, because everywhere home growth, home cultivation is subject to have an impact on the black market, on criminality, on crime rates, and there are concerns that are founded on some unrealistic scenarios, but many are legitimate. The second reason why this amendment is particularly important because of the agreements between the Government of Canada and some provinces, Quebec and Manitoba, that will lead to confusion and has been in confusion for some time. The government has rejected an amendment that would prevent people from displacing an illegal market. Home grow will be very difficult to control and may well bleed into the illegal market. The federal government is saying that this will help people in remote areas to obtain a legal supply. But the reality is that Ottawa knows nothing about it because the retail will be dealt with by the provinces, and all provinces will have a competitive pricing framework for marijuana, but all want to eliminate the illicit market.
compromise solution to these problems, a solution based on the approach that the Supreme Court has repeatedly called for in instances such as this, where the federal and the provincial government's jurisdictions overlapped, cooperative federalism. In the case of home cultivation of marijuana, the Government of Canada is using its criminal law power to impose on provinces a positive right to grow cannabis, a right derived from the federal criminal law power that applies to all dwellings of the country, irrespective of the circumstances and the choices of the different regions. According to the government's representative's speech last night, a single plant separates the provinces and the government, since it will be permissible for provinces to lower the number of plants that people are allowed to grow at home. It may appear like a single plant, but behind this plant lies an important principle. Can provinces freely legislate within their areas of jurisdiction, in this instance, property and civil rights, or does federal paramountcy apply? The implications of this issue go far beyond the cannabis debate, as each recourse to the paramountcy doctrine by the government and its interpretation by the courts have a crucial impact on the nature of the Canadian Federation. Je précise que pour ma part, je suis favorable.
I am in favor of home cultivation. I know it would be a legal product. It should be authorized, subject to some very stringent limitations, as provided for the Cannabis Act and provincial and municipal legislation. But I know that unfavorable arguments are equally as valid as those that are put forward by the Government of Canada. When there are solid arguments on both sides, and it is a matter of shared jurisdiction, it is better to leave the provinces the leeway that they need to deal with solutions that could better correspond to their reality and the choices of their people. The representative of the government is right to say that a certain flexibility is inherent in C-45, but that flexibility the Government of Canada has decided what it will be unilaterally. And with respect to provincial jurisdiction and personal home cultivation, they say we feel it is justifiable and reasonable, but unfortunately don't see it that way.
Mix of disappointment and anger at the government's reply on this point. But emotion is a poor advisor in such circumstances, especially if you are to provide sober second thought. Today, we are here to decide not how we will express our frustration. We are here to decide whether we should vote in favor of the government's message or insist on this amendment. Underlying this decision is our answer to two questions. Would we be able to convince the government to reverse its decision as regards this amendment? And two, in whatever we choose to do, how best can we preserve, if not enhance, the Senate's reputation and credibility? Pourrions-nous, en insistant sur cette...
By insisting on this amendment, can we bring the government to change its mind? Considering that the Prime Minister has put his personal credibility online on this matter, I think it would be very difficult. It would be a long-term struggle. The Senate has to mobilize on its side a major part of the Canadian population. Such a scenario seems quite improbable to me. To be very frank, I don't think that such a fight would be justifiable. The home cultivation and jurisdiction are both important issues, but to trigger a political crisis on that basis, well, I don't think so. Particularly since there is another remedy for the provinces, that is to address the courts. That ultimate voice, the legal voice, is a perhaps better path, a more promising and wiser path to take. The least probable outcome, if the Senate insists on voting on this amendment, is that we would vote only the one time. The government, 24 or 48 hours later, would once again reject the same amendment, and therefore we would have to defer to the House of Commons. What would we gain? What would we win? Many people might wonder then why we provoked this upset, if only to hurriedly leave the Senate to go on our summer vacation. Now, a second matter. How will you be able to preserve, to burnish, and to keep the reputation of the Senate in the eyes of the people?
With the lens of the Senate's reputation and credibility. The Senate's credibility is fragile, as you know. The serious work done on C-45 has contributed to its enhancement, but any faux pas at this stage could risk the modest gains that we have made. Insisting should be reserved to relatively rare cases, where the issue is of special importance related to our constitutional role, where we are prepared to lead a serious fight and see its completion, when a significant part of public opinion is or could be on our side, although there could be exceptions, and where there are realistic prospects of convincing or forcing the government to change its mind. Let us see how the issue before us fits these four criteria. 1, the matter of provincial jurisdiction over home cultivation of cannabis is important, but I don't think it is of such importance as to warrant an extraordinary intervention by the Parliament of Canada's upper house. 2, as I said, my sense is that the majority here are not prepared to fight for a long period with the government on this issue. 3, the chances of getting public opinion on our side are slim, except perhaps in Quebec, and even that is far from certain. 4, the odds of the government changing its mind are very small. Chers collègues, dans le dossier de la culture.
Dear colleagues, in this matter of home cultivation, the federal government wanted a more unifying rather than cooperative federalism, and it has created this issue. So what will be the result at home? Disappointment, anger, concern? But we should not be guided by those emotions. Reason must prevail. The credibility of the Senate as a complementary chamber is important, especially so since these measures must be very measured and carefully chosen. In any legislative struggle or combat, we have to be able to work with the government. We don't want to be in an arm wrestling match each time with the government. Clearly put, the issue is this. Do we have to provoke a parliamentary crisis that could last weeks in the hope of making the government back down on this matter, which is important but not crucial? I'm referring to home cultivation. I say no. I say no to this question. Do we do this for a symbol? To defer to the House of Commons? I also say no. I am in favor of the legalization of cannabis. I will vote against Senator Carignan's amendment.
C-45 was tabled in the Senate 7 months ago. There were many challenges on the road before us. However, we surpassed these challenges and completed a much more thorough examination of the bill than what the other place was able to deliver. We proposed important, reasonable amendments. The government accepted only 5 of them, but these will make the Cannabis Act a better law. In short, my friends, we can be proud, very proud, of the work that we have done. Now, if we insisted on this amendment to the bill, would we add anything significant to that work in the eyes of an ever-Senate skeptic Canadian population? Or would we risk lessening or even setting aside the considerable value of the Senate's contribution to this matter? Honourable Senators, in my opinion, the gains at play in this vote are very improbable, but the risks are high, not for the government, not for any party or group, but for the Senate. Thank you.
Senator Kachuk. Question? Senator Pratt, would you take a question?
Of course.
Senator Anderchuk.
Senator Pratt, I've listened to you, and you've indicated that we should put such great emphasis on the Senate and its reputation. When I understood our reputation should be based on following the Constitution, the Parliament of Canada Act, in serving the public. And we should really take the arguments and the reasoned approach and listen to each other. and see where that takes us to the public. I certainly find it difficult in your arguments, on the one hand, to hear you say that we should worry about the Senate. Then you anticipate what the House is going to do. This is a house of debate, so don't you believe that just by having this debate, we bring more knowledge, more education, maybe more Canadians will understand the issues? And isn't that one of our roles, not just worrying about our reputation, but how we serve the public?
Senator Pratt.
My sense of what most Canadians think at this moment, and would think if we insisted, I think most Canadians want us to pass the bill. That's my interpretation of what most Canadians think. And we've debated this bill now for 7 months. I think we've done our job. I don't think there would be much patience for us in Canada, from most Canadians, for us to delay passage